and circumstances of the offenses for which Ms. Richins has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant. The court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richins was convicted in reverse order. Ms. Richins, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years.
On May 13th, a Utah judge told Kouri Richins she was simply too dangerous to ever be free. Life without parole for poisoning her husband with fentanyl. Case closed, most people figured. Then, 7 weeks later, her attorneys filed something that changed the conversation entirely. A 14-page motion accusing that same judge of being biased against her in front of the jury the whole time. So, did Kouri Richins get a fair trial, or is this just what every convicted defendant's lawyers do? Let's go through exactly what they filed. If you're just catching up, here's where we are. Kouri Richins is a Kamas, Utah mother of 3, a former real estate agent. Her husband, Eric Richins, died at their home on March 4th, 2022. She called 911, saying he was cold. She wasn't arrested for over a year, and in that gap, she published a children's book about grief, which became its own controversy once people realized what she was accused.
This March, after a 3-week trial with more than 40 witnesses, a jury convicted her of aggravated murder, attempted aggravated murder from weeks earlier on Valentine's Day, insurance fraud, and forgery. They deliberated for about 3 hours. Then, in May, on what would have been Eric's 44th birthday, Judge Richard Mrazek sentenced her to life without the possibility of parole. At that sentencing, the couple's 3 sons had statements read on their behalf.
Jessica Black, I'm a licensed clinical mental health therapist and a registered play therapist. Myself and my colleagues are here today to read the victim impact statements for 3 children. We are here as advocates on their behalf. After a developmentally appropriate process, the boys were able to decide individually how they wanted to share their statements, and this is what they chose. Our roles are to read their words exactly as they wrote. The boys want the court and the world to hear their side. This is from WR. I woke up to sirens, and there were a lot of people at my house, and I was definitely scared. I felt confused. I was in a bedroom with my brothers, and I didn't know what was happening. At first, I was really scared because I didn't know what was happening, and I had no control, and I felt helpless. I felt really overwhelmed. After my dad died, Kouri would put us in the basement while she was with the neighbor. I felt scared because I thought something really bad was happening again.
Their mother, that they didn't want her ever released. Eric's family asked the same. Richins, for her part, read a letter to her boys insisting she didn't do it. Her attorneys said that day they'd be filing for a new trial. Nobody was surprised by that part. What surprised people was what the motion actually said once it landed. Real quick, you've probably seen headlines calling this a judge recusing himself, and other outlets issuing corrections saying that's not quite right. That gap between what got reported and what actually happened in the filing is exactly why we go straight to the source documents on this channel, instead of just repeating the loudest headline. So let's get into what the paperwork. The motion
filed June 30th by attorneys Wendy Lewis, Catherine Nestor, and Alexander Ramos, makes 3 arguments. The first is judicial bias. The defense says Judge Murdaugh repeatedly interrupted them in front of the jury, corrected them in ways that made them look incompetent, and helped the prosecution with objections the state hadn't even raised. They point to specific numbers. On day 1 of the trial, they counted 36 interruptions directed at the defense, compared to 20 at the prosecution. On day 4, it was 24 to 13. They also cite specific phrases from the transcript, the judge telling defense counsel to pause, to stay focused, and during closing arguments, please be seated. They argue the pattern, not any single moment, is what mattered. The second argument is about financial evidence. Back in January, before the trial even started, the court set what the motion calls guardrails on how much of Richins' financial history, separate from the murder case, prosecutors could bring in. The defense says the state blew past those limits anyway through 2 witnesses, Brooke Carrington, who testified about bounced checks and mismanaged business finances, and Chelsea Barney, a former close friend, who testified she lost her home and savings in a real estate deal with Richins gone wrong. The defense says roughly 7 pages of the prosecution's closing argument focused on that testimony and argues it paints honest in a way that had nothing to do with proving she killed her husband. Here's where it gets interesting from a legal standpoint. The defense directly compares this to Alex Murdaugh, the South Carolina attorney convicted of killing his wife and son, whose conviction the state Supreme Court overturned this past May, partly because prosecutors used years of his financial misconduct to argue motive. The defense is saying that was ruled prejudicial there. It should be ruled prejudicial here, too. The third argument is what's called cumulative error. The idea that even if no single mistake is big enough on its own, several of them added together can still deny someone a fair trial. Utah law requires at least 2 real errors, each with the potential to have affected the outcome, that together shake confidence in the fairness of the whole trial. Now, about that recusal confusion. What actually happened is more precise than the judge stepped down. Murdaugh treated the bias accusation as a formal request to disqualify him, and under Utah court rules, that kind of request doesn't get decided by the judge being accused. It gets sent up to the associate presiding judge of the district to review. That's what Murdaugh did on July 1st, saying he'd take no further action until it's resolved. Functionally, the case is paused either way. Legally, it's a certification, not a self-recusal, and that distinction matters for what happens next. So how seriously should this be taken? We looked at reactions from attorneys who actually sat through the trial, and the reads are split, but leaning skeptical of the bias claim specifically. One defense attorney, who represented Richins earlier in the case, before the trial itself, said she personally never experienced the judge treating attorneys unfairly in any of her own appearances before him, and called motions like this fairly standard after any conviction. Attorneys tend to include everything that might possibly stick, even if some of it reads as minor once you're outside the emotion of the trial. She specifically flagged the interruption count numbers as weak on their own, since judges interrupt both sides constantly, and the question is really about the nature of those interruptions, not the tally. A former prosecutor who's tried cases across the country echoed that. She said it's common, almost expected, for defense teams to blame the judge post-conviction, and that appellate courts aren't looking for hurt feelings, they're looking for actual abuse of discretion. She also noted something specific. Judges are human, and showing frustration with one side doesn't automatically mean bias. What would matter more is whether the jury's verdict would...
Where both of them agreed the argument has real legs is the financial evidence piece, specifically because of the timing. The Murdaugh reversal happened just weeks before this motion was filed, over almost the identical legal theory. That's not something either side can just wave off. So where does this actually stand right now? As of this recording, the Associate Presiding Judge of the 3rd District hasn't ruled on whether Mrazek is disqualified, and no new judge has been publicly assigned to hear the retrial motion. The state hasn't filed its response yet either, and that response, when it comes, is going to matter as much as the original motion, since prosecutors get to push back on every one of these claims point by point. There's also a second case sitting in the background. Richins separately faces 26 felony counts tied to alleged financial crimes filed just last month, and it's not clear yet whether prosecutors are still planning to move forward with that one while this motion is pending.
This one's genuinely still open, and we're not going to pretend otherwise just to wrap things up neatly. What we will do is keep pulling the actual filings instead of just repeating whatever headline moves fastest. That's the whole point of this channel. If you want to know the moment the state responds or a new judge gets named, subscribe and turn on notifications, because this case is far from finished. We'll be back with it.